and 2023-0091, continuation of jury trial. Counsel is present in court. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yas for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
Morning. We need the defendant.
Thank you, gentlemen.
Your Honor, for the record, the defendant's present in the courtroom.
Thank you, Madam Clerk. All right, at the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty, and I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion to eliminate to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in a juvenile applies with equal force. If the defendant, a defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116-124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light of my ruling.
It's moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago I did review what the defendant filed this morning. It's just not 216, it's 318. All right. On the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they have no intention, they've told us they have no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct the colloquy with the defendant at this point.
Would you like them sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move.
Welcome to Zoom Government. Enter your participant ID. Please enter the meeting code. The meeting has not started.
You see the clerk for a second.
Madam Clerk.
Thank you, Judge.
Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing shall be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing? So help you God.
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you, that is, the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walshe, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
rise. Jurors entering.
Hear ye, hear ye, hear ye. All persons have anything to do with the Honorable Diane Fernandez, Justice of the Norfolk Superior Court, for your attention, you may be heard. Let's have a call from Massachusetts in this honorable court. Please be seated. Please turn off your cell phones.
Morning, jurors. Morning. Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case? Yes. Were you able to comply with my order that you not do any research about the case? Yes. Were you able to comply with my order that you not go on any social media or access any news media? Yes. And do you still all have open minds? Yes. With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
I sort of see it as different chapters of the book. And another chapter of the book has just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth. All right? So what happens next? What happens next is the next chapter we're going to go to as we move towards your deliberations is that really 2 things that happens interspersed. I'll explain. The 2 things that need left to be done is I need to give you my jury charge, my legal instructions to you. And then you need to hear the closing arguments of counsel. Right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that, the crime that is charged here, murder. Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So those 2 parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And there, I get the input from the lawyers of what they're seeing. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise for the court, please. Jurors, close your notebooks and follow me.
Thank you. Couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about, during Mr. Mutlu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe. With the hammer?
No.
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that transcript.
I want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mutlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I have had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday, and I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions, and I made a mental note to go back to those this morning, but I didn't, frankly, have a chance to do that. Since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in that I don't go over now that you want to persist with, just...
Your Honor, there is actually, with respect to the consciousness of guilt instruction potentially, I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this. The draft instructions as I have them right now includes what I tried to do is when I was scratching my head saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics so that that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now for, and this is in part 2 of the instructions, impeachment by prior conviction impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
And who's closing for the Commonwealth?
I
The address of the Refuse Center, 300 Forest Street, Peabody?
Yes, Your Honor.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it. Commonwealth seeking a mode of instruction.
Yes, Your Honor.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided, and then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that I mean there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's sort of the second half of the instructions that the special instructions I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? 88 Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an issue.
I know. I said
So,
it should have been.
so just take it, can I take it out?
Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me. But I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them. I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Yes, Your Honor.
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law. But I'll get it to you.
Thank you, Your Honor.
All rise.